You became a citizen on a Tuesday morning. You raised your right hand. You said the oath. You cried. Your family cried. You thought that was the finish line. You thought nothing could touch you after that. Then one morning, a letter arrives from the Department of Justice, not USCIS, the Department of Justice. You read the first paragraph and your stomach drops. The federal government is reviewing your naturalization. They believe you voted in an election you were not eligible to vote in. They are opening a case to revoke your citizenship. You think this must be a mistake. You have done nothing wrong. You have been a law-abiding, tax-paying, contributing member of this country for years. But here's the thing no one told you when you raised that hand and said that oath. Citizenship in the United States can be taken back. And in 2026, the government is doing exactly that at a scale this country has not seen in generations. My name is James. I am a senior immigration analyst with 6 years of federal policy experience. On Immigration News Today, I do not give you opinions. I give you the law, the loopholes, and the survival strategies that keep families together. I am not your attorney. This is educational information only. For your specific case, consult a licensed immigration lawyer. Here is what USCIS is counting on you not knowing. The White House has provided DHS with a list of over 1,000 names. These are naturalized American citizens. Every single one of them is under suspicion for what the administration is calling illegal voting, specifically casting a ballot in a federal or state election prior to completing the naturalization process. The Department of Justice has established what internal memos are now describing as a denaturalization referral pipeline, processing between 100 and 200 cases per month for potential citizenship revocation proceedings. This is not a future plan. This is happening right now, in February 2026, and the people on that list do not know they are on it. There is no notification. There is no warning letter before the legal process begins. The first time many of these individuals will know they are a target is when a federal complaint is filed against them in district court. The legal mechanism being used is denaturalization under INA Section 340, which allows the government to revoke naturalization that was illegally procured or procured by concealment of a material fact or willful misrepresentation. The government's current argument is that any naturalized citizen who voted before completing citizenship, even by mistake, even because of a clerical error by a county election office, even because they were given incorrect information by a poll worker, made a willful misrepresentation on their N-400 application, specifically in the section where applicants certify they have never claimed to be a U.S. citizen in order to vote. That is the hook. A single check mark on a government form, answered years ago, possibly under confusion, possibly under incorrect guidance, is now being used as the basis to strip people of the citizenship they earned. But here is the trapdoor most people fall through. Many naturalized citizens who voted before their citizenship was finalized did so because they were incorrectly registered to vote by state or county election systems that did not properly filter non-citizen applicants from the voter rolls. In some states, driver's license applications are automatically linked to voter registration systems. A permanent resident who got a new license was sometimes automatically added to voter rolls without their knowledge or consent. Some of these people received a voter registration card in the mail, assumed it was legitimate, and voted. They did not lie. They were given incorrect access by a broken system. But the current DOJ posture treats the act of voting, regardless of how access was obtained, as evidence of willful misrepresentation on the naturalization application. Now let me tell you about David. He came to the United States from the Philippines in 2009. He became a lawful permanent resident in 2013. In 2016, he renewed his driver's license in a state with an automatic voter registration system. He received a voter registration card. He assumed it was legal. He voted in the 2016 presidential election. He never voted again because a neighbor mentioned it might be an issue. He did not disclose this on his N-400 when he naturalized in 2019 because he believed he had resolved it, and because he was told by a notario, not a licensed attorney, that it was not a problem. He took the oath. He became a citizen. He has been a citizen for 6 years. He has a U.S.-born daughter. He owns a small business. And in January 2026, his name appeared on a federal referral list because his 2016 ballot record matched his naturalization file in a database cross-reference. He has not been served yet, but the case is being built. David's situation is not unusual. It is the exact profile this task force is targeting. The silent killer in this process is hidden in the N400 certification section. Question 29 on the form N400 asks whether you have ever claimed to be a U.S. citizen in writing or in any other way. Question 30 asks whether you have ever registered to vote or voted in any federal, state, or local election in the United States. If you answered no to either of those questions and you had, in fact, been registered to vote or had cast a ballot, even unknowingly, even due to a system error, the government now has what it considers a written record of material misrepresentation. Under Cungis v. United States, 485 U.S. 759, decided in 1988, the Supreme Court established that a misrepresentation is material for denaturalization purposes if it had a natural tendency to influence the decisions of the immigration authorities. The government does not need to prove the misrepresentation actually affected the outcome. It only needs to show it could have. That is a very low bar. Oh, stop. Before you do anything else, write this down. If you are a naturalized citizen and you have any history of voter registration or voting prior to your naturalization, even a registration you did not initiate, even a single ballot cast years ago, you need to pull out your N400 application today. Find the copy you kept or request it through a Freedom of Information Act request to USCIS. Read your answers to questions 29 and 30. Compare those answers to your actual voting history. If there is any discrepancy, any at all, you need to speak with an immigration attorney before you receive any government contact. The moment a complaint is filed in federal court, the legal posture of your case changes dramatically and your options narrow. What I am about to tell you contradicts what most lawyers say. The standard advice from immigration attorneys right now is that denaturalization is extremely rare and that the courts have historically been reluctant to strip citizenship. That is true historically. But the current environment is not historical. The DOJ is processing 100 to 200 referrals per month. Federal district courts are being asked to handle these cases on an accelerated docket. And unlike in criminal proceedings, denaturalization is a civil action, which means the government only needs to prove its case by clear and convincing evidence, not beyond a reasonable doubt. Clear and convincing is a significantly lower standard. The government does not need to prove you intended to commit fraud. It needs to convince a federal judge that the record shows you were not fully truthful on your N400. In this environment, passive waiting is not a legal strategy. There is a 72-hour window. Miss it, and this option disappears forever. If you have any concern about your voting history relative to your naturalization date, the most important thing you can do right now is establish attorney-client privilege with a licensed immigration attorney before any government contact reaches you. Once you receive a target letter, a civil complaint filing, or any written government inquiry, everything you say and do becomes part of the record. Establishing privilege now means you can speak freely, assess your exposure honestly, and build a response strategy without that conversation ever being disclosed. Waiting until you receive a letter means you are responding under pressure with no preparation and no protection. Here is your action plan for the coming days. Tonight, locate your Certificate of Naturalization and your N400 application and review the date you took your oath of citizenship. Then check your state's voter registration records, which are publicly available through your county election office website, and confirm the date you were first registered. If the registration date is earlier than your naturalization date, note that discrepancy and do not discuss it with anyone except a licensed immigration attorney. Separately, check whether your state uses an automatic voter registration system tied to driver's license applications, because that documentation could be critical to a defense showing your registration was not willful. If you naturalized after 2016 and voted in any election before that naturalization date, Treat this as urgent and contact an immigration attorney this week, not next month. Finally, do not respond to any government letter, questionnaire, or phone call regarding your voting history or citizenship without speaking to an attorney first. Any statement you make, even an innocent clarification, can be used against you in a denaturalization proceeding. Immigration rules change overnight. One executive order, one court ruling, and everything shifts. I send urgent alerts to my WhatsApp community before I even post on YouTube. The link is in the description and pinned comment. Join now. It is free, and it could save your case. If you want accurate, fast, and reliable immigration updates, subscribe to Immigration News Today right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It is essential. I am James. Protect your status. Protect your family. I will see you in the next update.